Hello and welcome everyone to this webinar, which is being brought to you by the Chartered Institute of Arbitrators as part of the Vis East Moot, and will examine the question of whether dispute resolution mechanisms providing for international arbitration can help support or impede the goals of the Paris Agreement in both the commercial and the investor state context. We will also be looking at whether traditional mechanisms of dispute resolution need to be recalibrated in order to meet the challenges of the energy transition in the short time frame left. We have an excellent panel of experts ready to discuss these important issues. But before I move on to introductions, I have a couple of brief housekeeping matters to address. First, I would like to remind the audience that this webinar is being recorded. Second, in terms of the format of today's webinar, the panelists will first be invited to give presentations of about 15 minutes each, after which we will have the opportunity to put any questions from the audience to the panelists. However, we do invite you to send in your questions via the Q&A box at the bottom of your screen as and when they arise. If you see a question posted by someone else which you support, you can bring this to our attention by upvoting their comment. If your question is directed at a particular speaker, please make this clear when leaving your comment. And finally, you can use the chat function for general discussion or to flag any technical problems. So next, I have the great pleasure of introducing our panelists, each of whom bring their unique perspective and expertise to the topic of today's webinar. First, we will hear from Ned Beale, who is a partner in the London office of Housefield & Co. LL.P. Ned appears in international arbitration as counsel, advocate, and arbitrator, and his work covers the full spectrum of commercial disputes. Ned will present on the rise of climate-related conflict risk in the context of commercial arbitration and litigation, and will address the question of whether traditional dispute resolution mechanisms are critical to ensuring a successful energy transition. Second, we will hear from Wolf von Kumberg. Wolf is a leading internationally recognized independent arbitrator and mediator based out of Arbitra International in London and Washington, D.C. Wolf has over 30 years of experience in complex commercial disputes within international business, and Wolf will present on the topic of expanding the ADR toolkit for climate change disputes, and will explore whether traditional mechanisms of dispute resolution need to be recalibrated in order to meet the challenges of the energy transition and the goals of the Paris Agreement. Unfortunately, Wolf is not able to join us live this morning as he was experiencing some technical difficulties with his connection. However, the Chartered Institute has worked its magic, and Wolf was able to pre-record his presentation for the benefit of the webinar today. Our third panelist is Annette Magnusson, co-founder of Climate Change Council, a think and do tank with a mission to mobilize law and lawyers for climate action. Annette will present on the findings of Climate Change Council's report on the Energy Charter Treaty, Climate Change, and the Energy Transition, which explores whether the Energy Charter Treaty, a critical multilateral instrument for investment protection in the energy sector, supports or impedes the goals of the Paris Agreement. We have a lot to cover, so I will turn it over to Ned to kick us off with his presentation.
Thanks very much, Jessica, for that introduction. Thanks everybody for joining this morning, and thanks to Lewis Johnson and the team at the Chartered Institute of Arbitrators for setting up this session, which I think is very interesting and very timely. In my presentation, I'm going to focus on private law climate change claims, both in arbitration and by way of comparison in court. That fits in with my own practice, which is very much a traditional commercial arbitration and commercial litigation practice. Having said that, my firm Housefield has a dedicated environmental disputes team, which for many years has had what I'd call a traditional plaintiff environmental practice. So going back to acting for native Alaskans who were victims of the Exxon Valdez oil spill back in the 90s, through to the present when we're acting for Zambian communities who suffer from pollution emitted by a copper mine. And what I find really interesting about this topic is that it straddles those two quite different practice areas. So the description climate change arbitration could equally encompass, to take two matters we're acting on, South Pacific Islanders adversely affected by rising sea levels, or an arbitration under a joint venture agreement between two solar power producers, albeit the first is very much a classic public interest claim, and the second is, I suppose, a classic private law dispute. So what I hope to do in the next 10 minutes or so is to take you through a kind of whistle-top tour of the reasons why I think private law climate change disputes, particularly around energy transition, will increase, what types of disputes we'll see, and how arbitration can help resolve them. Would it be okay to put my slides up? Brilliant. So, second slide, please. So, will energy transition cause disputes, and if so, why? Well, as Jessica said at the outset, the most common avenue of climate-related disputes to date relate to transition risks, namely those that arise through the process of adjustment towards a low-carbon economy. And I think it's probably not controversial that that transition is and will continue to cause disputes. Why? I pick out 4 reasons. First, regulation. From the Paris Agreement down, nations have and will continue to enact legislation and regulation designed to ensure the Paris targets are met. 2 points in particular to draw out. First, I think a lot of that regulation will be around disclosure requirements. So, for example, last week, the SEC in America announced a new proposed rule of mandatory climate change disclosures, which will really be onerous for SEC-listed companies. Second, a lot of this regulation is in fact self-regulation, where specific industries adopt best practice standards over and above the statutory minimums. And international arbitration itself, of course, has a nice example of this in the campaign for greener arbitration's green protocols. Second, technology. I think and hope we will continue to see innovation in low carbon energy production methods. Thirdly, pricing. Energy pricing should move to more accurately reflect the overall environmental cost of energy production. It would be nice to think that that reduces volatility, but it would seem to me that, not that I think the energy price can become more volatile after the events of the last couple of weeks, but it seems to me likely that a rapid movement away from fossil fuels won't help volatility. And fourthly, consumption. Hopefully all of these movements will drive changes in consumption which will help reach the Paris targets. And indeed lots of people, either individually or collectively through workplaces or other associations, are voluntarily changing patterns of energy consumption to meet those targets. Now, of course, all of this is good and just what's necessary to meet the Paris targets. However, my experience over the years as an arbitrator and litigator, if it's taught me anything, it's that disruption drives disputes. And certainly in a private law context, my experience is the vast majority of commercial claims arise where the parties face a situation they didn't foresee when they entered into their contract, and their contract doesn't legislate for. And it seems to me it's very likely that all of these different changes engendered by climate change and energy transition to try to mitigate climate change will produce just those sorts of situations. And I think added to that, we're increasingly seeing NGOs and people interested by climate change bringing private law disputes for strategic reasons to try to accelerate mitigation. So next slide, please. So what sorts of disputes will we see? Well, I didn't want to reinvent the wheel, so I'll refer you to the ICC Commission report, Resolving Climate Change-Related Disputes for Arbitration and ADR, which Wendy Miles and others produced in 2019, which is really an excellent report. It picks out three categories of contracts which may give rise to climate change arbitration. They're up on the slide, so I won't read them out, but you see that category 1 is contracts directly entered into to implement energy transition. So that would be, I don't know, a dispute between the owner and a firm of engineers about whether a new solar power plant meets the requisite energy output. That would be a classic dispute under a category 1 contract. Category 2 contracts are contracts not specifically related to transition, but related to the rise in global temperatures. And for example, a category 2 dispute could be a dispute between the buyer and the seller of a business as to whether the business's environmental warranties adequately disclose the risk of flooding for a low-lying factory. Category 3 is an interesting one. These are submission agreements where the parties voluntarily agree to arbitrate a climate change dispute, and they might do that to prevent multi-jurisdiction court proceedings. This is really an aspirational category. There aren't many instances of this in practice as yet, although a nice example cited in the report, albeit not in the climate change space, is the agreement between Bangladeshi unions and clothing manufacturers to submit work safety disputes to the Permanent Court of Arbitration. So those are the 3 categories the ICC task force picked out a couple of years ago. I would like to wonder whether there's a 4th category. And certainly in the UK, we see contracts of all type increasingly imposing obligations on parties relating to climate change in really the same way that you see boilerplate language stating that parties will comply with money laundering or sanctions. So again, in the UK, the Chancery Lane project is a good example of an attempt to draw together contractual wording of this type for businesses and lawyers. And that's all good in principle, but in practice, if there are additional contractual obligations relating to climate change, it gives counterparties additional bases to bring claims if those obligations aren't complied with, again, either for commercial reasons or for strategic reasons. And I do think that the more parties build climate change obligations into their contracts, the more likely we're going to see disputes arising out of them. Next slide, please. So, how can arbitration help resolve climate change disputes? I will pick out 3 reasons I think it can. First is flexibility. I think that I don't need to talk to this audience about the flexibility generally of international arbitration, but I just would like to give a real life example. I was acting for one half of a solar power joint venture who ended up in a dispute with their joint venture party because of the change in the solar tariff rebates implemented by the UK government. And that change just produced a commercial situation that the parties hadn't contemplated and the contract didn't legislate for. So we had a classic joint venture contractual dispute. And we discussed it with the clients, and I explained the court process. And the English courts like to think that they're streamlined and they're quick, but I said in reality you're looking at 1.5 to 2 years to go through pleadings, a case management conference, a certain amount of disclosure, witness statements, a trial, judgment. And that just didn't work for either party who had an ongoing joint venture and needed to know where they stood commercially. So the parties collectively devised an ad hoc arbitration process, which had limited statements of case over 3 weeks, short witness statements over 2 weeks, a 1-day hearing before an arbitrator, and the arbitrator agreed to produce their award in 2 weeks. And that was just an example of a transition dispute where I have no doubt that international arbitration got us to a resolution between the parties much quicker than certainly the English court could have done so. Secondly, contractual integrity. I've put on this slide Marmot oil versus Octa crude oil. This was a dispute about the supply of crude oil, which gave rise to actually quite a lot of English judgments. And the one I'm referring to is a 2001 Court of Appeal judgment. And that set out 10 principles for determining whether a contract is void for uncertainty. And principle 10, set out by Lord Justice Ricks, is that the presence of an arbitration agreement provides a commercial and contractual mechanism in the absence of agreement between the parties to resolve disputes with the assistance of experts in the field. So what the Court of Appeal was saying here, that it is more likely a contract will avoid being void for uncertainty if it's got an arbitration agreement. And I think in a rapidly evolving space where you have changes in regulation, changes in pricing, and that's very likely to produce uncertainty, I think that's very important. So I think it's arbitration produces a contractual situation where it's more likely a contract can keep in place through those periods of uncertainty. And finally, international disputes. Again, I'm sure I don't need to tell this audience the usual advantages of arbitration in the New York Convention for International Disputes. But I think in the climate change space, there are some specific advantages. I think it's fair to say that victims of climate change may well be disproportionately located in the global south, where some court systems have issues both for plaintiffs and defendants. And it may well be that the victims of climate change go across state boundaries. So I think this is really a situation where submission agreements to arbitration can give parties access to a way of resolving disputes, which is going to be preferable to the national courts in the jurisdictions of the victims, and I think is going to be preferable to the type of what you sometimes call forum shopping or litigation tourism that you see claimant groups looking to bring proceedings in, for example, the English or US courts. And I know the English courts are fairly sceptical about that. So this is really going back to the ICC's third category of contracts. I really think it is somewhere where international arbitration can step in and fill in access to justice gap. Next slide, please. So what's coming next? Just to deal with this briefly, again, I pick out three things. In the UK, everybody is talking about greenwashing. And greenwashing is making commitments and representations about your compliance with climate change standards without backing those up. And it is again great that companies across the board are pledging themselves to meet these standards, but a lot of people are wondering whether they actually are doing so. And at the moment, that's quite regulator-led in the UK. The Financial Conduct Authority, the Competition Markets Authority, the Advertising Standards Agency are all looking at these types of issues. But certainly, the claimant bar, as you might call it, in the UK are looking at private law claims, both strategic and commercial, arising out of these sorts of issues. Second, I mentioned this at the start, but private law claims aimed at accelerating transition. Probably the best known of these is Milio Defence and Shell. In May 2021, the Hague District Court in the Netherlands granted a claim by Dutch NGOs ordering energy company Shell to reduce its group-wide CO2 emissions by 45% net compared to 2019 levels by the end of 2030. That decision is being appealed, but it is enforceable in the meantime. And it's well known and hugely interesting because the Dutch court felt able, under Dutch law, to find that Shell owed a duty of care to Dutch citizens to effectively comply with the Paris targets, and was confident enough to hold that Shell's current policies breached that duty. And I think there was a similar claim brought in England just the week before last. And I think we'll see many more of those sorts of claims. And finally, I just thought I'd mention tribunals' independent duties to deliver awards consistent with climate change law and treaty obligations. And I mentioned money laundering earlier. I think everybody knows a tribunal can't breach money laundering regulations. I wonder in the future whether arbitrators will need to consider climate change obligations when they're delivering awards. And just if the directors of Shell have a duty of care, do arbitrators have a duty of care? Anyhow, I have reached my 15 minutes, so I will end there. Thank you for listening. I'm very happy to answer questions later on or through the chat.
Thank you, Ned, for that great overview of the physical and transition risks that will arise as a result of the energy transition and the role of arbitration in commercial climate-related disputes, as well as climate justice. That's very interesting. It's all very interesting, and I'm sure we'll have a great discussion about that later. This leads very well into our next segment, which we will hear from Wolf on whether we should be expanding the ADR toolkit for climate change disputes. So I'll now turn over to Wolf.
The question I'm addressing is whether the ADR toolkit has to be expanded to deal with climate change disputes. So we know that the Paris Agreement has sent a clear signal to energy producers and consumers alike about the need to decarbonize the energy sector in order to achieve its overarching goals. It's clear that the energy transition cannot be achieved without adversely affecting directly or indirectly many existing commercial actors. The greatest and most imminent impact will be felt by fossil fuel energy producers, transportation, aviation, aerospace, carbon-heavy industries, and agricultural practices. This includes investments made in furtherance of the Paris Agreement, as well as those negatively impacted by environmental regulatory change, which will inevitably result in international conflicts and disputes. Already in the last decade, the number of investment disputes with environmental components has increased steeply, and it's anticipated there will be many more arising out of policies enacted to align domestic law with international commitments under the Paris Agreement. Disputes arising due to this transformation will detract from the ultimate objective to meet emissions reduction goals in the very short time frame left. It's trite to say that traditional mechanisms of dispute resolution are costly, time-consuming, destructive to relationships, and do not ultimately provide an adequate remedy for the environmental issues at hand. While such methods might clarify legal rights between specific parties, this is not the solution to the broader issues of meeting climate goals. To make real progress, we require collaboration and compromise to find lasting solutions. The achievement of the environmental sustainability goals in the short time frame left therefore require innovation in the approach to international dispute resolution. Sustainable energy projects and emission reduction commitments made by states must be implemented rapidly in order to meet the long-term temperature targets of the Paris Agreement. It is therefore imperative that lengthy disputes do not disrupt this progress. Traditional methods of dispute resolution, such as litigation, are not an answer to the effective prevention or management of these disputes, as they do not address the fundamental issues of transitional change. What is required is a mechanism that allows relationships to be restructured and not terminated. Early dispute avoidance and resolution rather than adversarial engagement will play an important role. In effect, what is needed is a collaborative conflict risk management approach. What I'd like to explore with you is a number of such mechanisms that can be used for this purpose. The first two I'd like to discuss are facilitated negotiation and mediation. So facilitated negotiation, in essence, is using a neutral to assist parties in exploring at an early stage the issues that have risen between them. It is less formal than mediation, and the neutral will play an active role in helping the parties to develop options and solutions to resolve their differences. For this purpose, it is useful for the neutral to have subject matter expertise. The neutral will help the parties to prepare the process and ensure that each has prepared a negotiation plan. The neutral will work largely with the parties in joint meetings, and the degree of confidentiality that applies will be agreed by the parties and the neutral. So this is a mechanism that is particularly apt to restructuring current relationships to meet energy transition requirements. Mediation, while it is also a form of facilitated negotiation, is a more formal process and is often employed once a dispute has arisen. Confidentiality is therefore an important element of the process. The mediator will meet privately with parties and in joint sessions as deemed appropriate. Mediator skills, rather than expertise, are important attributes for the mediator to have. The mediator will assist the parties to formulate options, but will not develop solutions themselves. So what are the key benefits of both of these processes in dealing with the energy transition issues? Well, both of these processes help preserve relationships and potentially permit contracts to continue by being through restructuring over a transition period. So this is going to be critical for the phase out of emissions. You simply can't reach these particular goals through litigation. The remedies simply aren't available through litigation. Both of these methods can be attempted at an early stage. There needn't be a conflict at all. In fact, the facilitated negotiation process can be utilized once parties understand that a contract needs to be restructured to meet the energy goals that the parties have. So it can be attempted at an early stage and is a very cost-effective means of restructuring a legal relationship. It's also relatively quick. It can be achieved as quickly as the parties themselves desire to put the process in place. And it's effective because it allows the reduction goals of 2030 and 2050 to be achieved in an orderly manner. It also saves a lot of lost opportunity costs that often occurs with litigation, which might span several years before you reach a conclusion. An important element for both these mechanisms is the fact that they allow for solutions that go beyond the dispute itself. Given the relationship of the parties can, as part of their solution, incorporate other relationships that they might have with each other. For example, you could see reducing a concession agreement for the extraction of oil in return for that same company putting in place sustainable energy, be it wind farms or solar farms, and having an agreement with a state to enable them to do that kind of energy transition. It also allows for a range of stakeholders with an interest in that particular energy transition to take part in the process. These stakeholders could be communities, could be NGOs, could be other interested members of the public, and they thereby also have an opportunity to voice their ideas or concerns within this broader concept of dispute resolution. So it's an effective way to bring in other constituent parts and come up with a much more robust agreement at the end of the day. A further mechanism that I'd like to explore in particular as we look at investment in new green projects are conflict avoidance boards. Conflict avoidance boards are a type of dispute board. Dispute boards have, in essence, been around for the last 40 or 50 years, largely used in construction projects. With respect to green projects, building conflict avoidance boards or CABs into these projects will assist in managing conflicts and avoiding disputes, allowing projects to be completed at cost and on time. Given the need to complete projects within a clear framework to achieve climate goals, this is actually a very critical factor. So as I say, these CABs or conflict avoidance boards have their origins in dispute boards. Dispute boards can be classified really into two primary categories: dispute resolution boards and dispute adjudication boards. The former issue non-binding opinions, while the latter produce binding decisions. The conflict avoidance boards are slightly different in that they have as their primary objective the avoidance of disputes rather than the resolution of disputes. With that in mind, however, they clearly can have as a mandate also an adjudicative function. The Chartered Institute of Arbitrators launched a set of novel dispute board rules in 2014. These rules are slightly different from others in this area in that they emphasize the conflict avoidance element of the board rather than dispute resolution. In particular, the rules provide for the provision of informal advice in Article 12. And if I quote, it says, "The true mission of a dispute board is not judicial, rather it is to prevent formal disputes. The parties may at any time jointly refer a matter or dispute to the DB for it to give an informal advisory opinion as a means of dispute avoidance, and or informally discuss and attempt to resolve any disagreement that may have arisen between the parties during the performance of the contract." So as you can see, the board takes an active role in actually attempting with the parties to avoid disputes and to actually horizon scan for potential issues that can be brought to the attention of the parties and dealt with before they actually become a dispute. So they are really an improvement on the older dispute board model. And they're so effective, in fact, that the World Bank mandates for the use of these boards on all projects that it funds. And it should really become a standard mechanism to use in any green infrastructure project. So in effect, they should also be mandated in green projects, whether it be through regulation by government or it be through the requirement of funders, because funders in effect can require as part of the funding agreement that these these CABs be involved in the project right from the outset. So how do we encourage the use of these mechanisms that I've just described to you? So to ensure that facilitated negotiation, mediation, conflict avoidance boards become part of the energy transition plan. As I just alluded to, governments and funders will play an important role in dictating their use. Companies can also adopt conflict risk avoidance programs, incorporating these mechanisms to ensure that they are used in the energy transition plans that they themselves develop. It would also be essential that all of the stakeholders understand precisely how these mechanisms work and how they can be incorporated in their own energy transition plans. So I hope that has given you a bit of insight into alternative mechanisms that are more collaborative and might be more effective as we move through the energy transition. Thank you very much.
Some very interesting comments from Wolf about how our approach to dispute resolution may also need to be reimagined in light of the vast amount of change that the energy transition will bring in such a short period of time. It's interesting because facilitated negotiation, conflicts avoidance boards, and mediation are certainly not revolutionary, but of course will require the parties to become familiar and comfortable with these processes, which should be implemented much earlier in the dispute resolution process, or in some cases even before a dispute is formally arisen. Of course, arbitration is an option if this type of approach is unsuccessful, but it is interesting to start to think and expand our minds a little bit outside of the box of what has now become traditional ADR. So thank you very much for that, Wolf. We're now going to hear from Annette on the Climate Change Council report on the Energy Charter Treaty and the energy transition. Over to you, Annette.
Thank you very much, Jessica, and hello, everyone. It's very nice to be speaking to you here today, and thank you very much for the Chartered Institute of Arbitrators that organized this opportunity to talk about these important issues on how we can sort of tip all hands on deck, so to speak, to contribute to the climate change crisis, including international dispute resolution. So I will be speaking to you today from Climate Change Council, and just a brief introduction, sort of brief few words. What is the think and do tank in this field? We are a fairly new venture. We started about a year ago, me and my two co-founders, and we all have a background in international disputes. And then we have additional experiences and backgrounds that sort of we chip into the practice. And what we do at Climate Change Council is really to focus in three things. We focus on research and advocacy in different projects, and to sort of see how international law and international dispute resolution can contribute to the climate change transition. We try to mobilize commercial lawyers in the net zero transition by various initiatives, and sort of embedding that understanding that everyone needs to be involved. And the great interest for this webinar today is a good testament to that. And we're also partnering with law firms to sort of provide research and a neutral fora at times when needed, sort of an expert advice. And what I will be doing here today, I will sort of focus on the first bucket, research and advocacy projects, because I will introduce a study and report, as Jessica mentioned, where we talk about these issues. So if I can perhaps put the presentation up. The starting point here then to answer the question, is investment arbitration a sustainable option for climate disputes? I will talk about some of the findings in a report that we released just recently from Climate Change Council on this topic, the Energy Charter Treaty, climate change, and the clean energy transition. So I can go to the next slide, please. And just to give you a brief background to the study, the purpose of the study was really trying to understand how the Energy Charter Treaty, as it now is formulated, and how it is now being applied, whether it contributes or impedes the necessary energy transition to meet the Paris Agreement targets, as Jessica described in her introduction. And the background to this is, of course, the debate in many camps on the value of not only the Energy Charter Treaty, but about bilateral investment treaties at large for the energy transition or for climate change mitigation and adaptation purposes at large. And more specifically, when it comes to the Energy Charter Treaty, the modernization process that is currently underway and the discussions relating to that process. So the objective, one of the objectives, of course, was to trying to understand what is happening and what has happened in the jurisprudence so far, and to the extent that is useful, to feed that into the modernization process, and by doing so through making sort of the findings of the study public through the report. It was very important when we set out to do this study that we applied a neutral perspective, meaning so we go in and study what has happened, so to speak, in the cases. We do not go in and try to review whether tribunals or parties argued in a way that we agree with or not agree with, or whether the tribunals were sort of correct or incorrect in their finding. Is really just trying to uncover what is happening in the cases and put it out there, and then to have a discussion beginning from that. So that was very important, that this study was being neutral. So that has really been the aim, to the best of our capabilities. And to achieve that, one of the methodologies we applied has been to begin with a desk study and begin with really asking all the different stakeholders involved in this process on their views, what they would think would be interesting or important questions to ask for a study like this. So we have done pretty much a 360 analysis of the different voices that need to be heard in carving out the methodology for the study. So we started with these stakeholder interviews, and then of course we had to collect all of the awards. We found 64 awards, or we were able to review 64 awards, and we had to put a stop at the beginning of August last year before we went into the more analytical phases of the study. So not all of the awards, of course, are in the public domain, and we were not able to read all of the awards that had been rendered as of August last year, but pretty much we were able to read all of them, as you can see from the numbers. As in any study like this, there are limitations. As you can appreciate, it was a very short time frame that we went through all of the awards, and I have mentioned the confidentiality of some of the awards. And I think also one needs to be aware of the fact that this, if we look at sort of how investment arbitration and international investment law, the role it plays in the energy transition, then of course the Energy Charter Treaty is one piece of the puzzle. It's arguably a very, very important piece of the puzzle, since the Energy Charter Treaty is unique in the way it addresses investments in energy. But the international jurisprudence, or the entire jurisprudence of international investment law, is out there. And of course, it is frequent that tribunals and parties refer to decisions and principles as applied also outside the immediate ECT jurisprudence, because the principles are pretty much are very similar or the same even. So, but here we look only at the ECT jurisprudence. So that's one of the limitations. And when we look at sort of the effect of the ECT on the energy transition, and this is debated, or this is discussed in the report more extensively than I will go into here now, of course, is the fact that what doesn't happen is difficult to measure. So we do not know to the extent to which the threat, or the so-called chilling effect of a claim relating to issues of climate change have in the end led to something for policy not to be introduced by the governments. This is something that is much debated, again, in the international discussions on ISDS at large, and not least under the ECT. I think this discussion is an important one, but that's not something that we will really go into much detail on here today. But I do think it is an important one to have. So the full report is available on the Climate Change Council website. I would just now go into some of the interesting findings of the report. And really what the questions that we were asking specifically. So we wanted to look at the climate and energy transition issues specifically. So examples of questions that we have asked, and this again from having sort of designed the study from the stakeholder interviews, is asking ourselves if tribunals have applied the ECT environmental provisions, or if the tribunals have considered issues related to climate change and the energy transitions in the awards. If so, to what extent has this happened, in what contexts? And of course, we have also been looking at the interaction between the ECT and other treaties. Have tribunals considered treaties relating to climate or environmental law, for example, as applicable law? And if there has not been a sort of direct referral to other international instruments, how have tribunals weighed other treaties against the ECT? And can that tell us something about what could happen in future claims relating environmental law? And an associated issue with this is sort of the weighing that takes place when it comes to investor protection versus states' rights to regulate, right? So this is a very sort of central issue in the report, and that's something we think will be relevant going forward in future claims relating to climate change, not least the so-called fossil phase-out cases that are currently pending, but they are just at the beginning, and we will see how they will play out going forward. So this is sort of looking at how investment protection has been weighed against states' right to regulate in these cases, and if these findings could inform us or even help us predict how future tribunals may decide future climate-related cases. That's also something that's being discussed in the report. And as you can see here, then is an illustration of one of the elements of the first elements of the study. And this is, we did a keyword search of all the awards to trying to understand how present central climate change related issues are in the jurisprudence. And one of the main findings, you could call it, of the report, which you could say it's a finding, there was nothing there, but that in and of itself is a finding. And it is that international climate change law is really not a central element in the jurisprudence at all in these 64 awards that we have been able to review. You see here a number of keywords and to the extent to which they occur in the awards. And the keywords are collected, including from the stakeholder interviews. What would be of interest to see if the tribunals or the parties discussed in the awards? And again, you can see that very few of issues relating to the energy transition are actually discussed in these awards. If you look at the climate law framework, and the most important legal text or the legal instrument when it comes to climate law is probably the UNFCCC, the United Nations Framework Convention on Climate Change from 1992. It is mentioned in less than 20% of the awards, but only by way of background or the facts of the case, and it's never included in any reasoning of any tribunal. And equally absent is the Kyoto Protocol, where it's 78% of the awards, there is no mention of the Kyoto Protocol. And there's one award that includes a reference to the Kyoto Protocol in the analysis of the tribunal. So it's very absent. The Paris Agreement is not mentioned in any of these awards, which perhaps is not so surprising given that the Paris Agreement was signed in 2015. So it's not been there for very long, and we all know it takes time for claims for events to unfold that could give rise to a claim, and then of course before an award has been rendered once a claim has been filed. So it could be that the Paris Agreement is actually mentioned in cases that are not yet decided, so we do not have access to that. But again, in the awards we were able to assess, we do not see the Paris Agreement at all. And equally, if you look at the environmental aspects of the Energy Charter Treaty itself, there are provisions on sustainability in the Energy Charter Treaty, sustainability, renewable energy, and coordination of energy policy. So, for example, you find text to this effect in the treaty's preamble, when it refers to energy efficiency. environmental concerns, and it also mentions the UNFCCC. But again, these provisions have not played any significant role in the cases that we have seen. In Article 19 of the ECT, you find interesting language on environmental aspects. So Article 19 requires that signatory states minimize, in an economically efficient manner, harmful environmental impacts arising from energy use, and also that states take account of environmental considerations throughout the formulation and implementation of their energy policy. But again, this is not something that we see in the awards, and Article 9 is found in Part 4 of the Energy Charter Treaty, and the dispute resolution provision, Article 26, covers only obligations stated in Part 3 of the treaty. So one should perhaps not be very surprised about this. So there is this absence of the climate law issues that we know from outside the international investment law in the jurisprudence, and it's very few mentionings of the sustainability or provisions of the Energy Charter Treaty itself, the Article 19 and the Protocol on Energy Efficiency and related environmental aspects. I think we have 4 awards that mention Article 19, but no award mentioned the protocol. I should say the protocol is something that was negotiated and open for signature in parallel with the treaty. It is a legal binding part of the ECT framework for the states that have ratified it, and which of course the majority of the contracting states has done. But so it has soft obligations, and again, it's not covered by Article Part 3 dispute resolution provisions of the Energy Charter Treaty. So you could say it's a good intention, but it's not sort of played in the practical law when it comes to the application of the investment protection provisions of the treaty. So that's sort of a glimpse or a peek into some of the findings of the report. If we continue then to the next slide and sort of the other observations that we can find from the report. I have already mentioned here that we have seen limited discussion of climate change and the energy transition in the cases. And I think it's interesting also to note that if you look at the different groups of cases, so you could group them into cases relating to fossil fuel, and then you can rate renewable energy cases. And renewable energy cases is a large bulk of cases, where, for example, 42% of the awards relate to investments in solar energy, and the investments in the cases relating to fossil fuel is much less. We had 16% relating to oil, for example, and 12% relating to gas. Now, if you look at the 24 total 21 awards that relate to investments in fossil fuel, they are sort of, and here I call them not systematic in character, right? So they relate, for example, to licenses or to individual or isolated infrastructure investments, and some of them relate to exploitation of fossil fuel and explorations. But they are not sort of addressing the entire energy mix of the state. They are not systematic in character. But if you look at, for example, the renewable energy cases, that's a different picture, because almost all of them relate to policy initiatives from the states that address changing the entire energy mix of the state and changes in that policy system that gave rise to so many of these claims, particularly in Spain and in Italy. So the fossil fuel cases do not touch upon policy issues, whereas the renewable energy cases do. But the policy that being discussed in the renewable energy cases, again, it's not climate change policy primarily that is being analyzed. That's mentioned in the background to some of the cases, but the policy is more the budgetary policies and sort of a reasonable rate of return to investors and that types of fiscal policy in the systematic cases. But that's sort of an observation that we see in these cases. Going on to additional observations, if we go to the next slide, I think this is probably where we could have an interesting discussion if we are sort of going back to the title of this event: is arbitration a sustainable option for climate disputes and investment arbitration? Because if you look at sort of the energy transition, I mean, if I go back one step to say, when we talk about climate disputes, of course, that is a very, very wide concept. And Ned gave you a very good overview on the different sort of types of disputes you could sort of put under the umbrella of climate disputes. But if we look at these types of investment disputes, and if you look at even more narrow on the energy transition examples that we have in this report, I think part of the answer to the question if investment arbitration is a sustainable option for climate disputes could perhaps be found here in the first bullet. Because if you look at the provisions in Article 26.6 of the Energy Charter Treaty on applicable law, we see in the jurisprudence that tribunals do recognize that other elements of international law could be relevant when interpreting standards under the Energy Charter Treaty. They haven't done a lot of that, but again, the language of the treaty, I think, is quite clear. And different tribunals have interpreted it a bit differently. And of course, parties have argued it differently. But I do think it would be interesting to see future tribunals under this provision introduce international climate law into the proceedings, if the parties, I should say, let them, because of course, if the parties do not argue around this, then it's difficult for the tribunal to introduce it into their analysis. But I think this is an interesting area, which I hope we will see some interesting develop going further in future cases. I think one should not forget that sort of all of these cases, it depends on the people involved and their experience of the people involved. The application of the international treaties very much depends on how they're argued and how that argument is being received by the tribunals listening to the counsel involved on each side. And again, I think to widen the perspective to somewhat when cases are being argued and include the climate change perspective, I think that would be interesting to see how that could going forward. And I should say that the need or the wish to widen the perspective when it comes to international investment disputes outside sort of the immediate parties involved or the immediate interests involved. For example, it's not unique for climate change. We have had this discussion for, I would say, many years when it comes to human rights, because there are other interests, or there could be other interests involved in an investment arbitration case than the immediate interests of those involved in the actual disputes. I mean, if you look at commercial arbitration, that's sort of one of the keys there. It's the parties that are involved in the disputes, and it's between those parties, and that's sort of the dispute that is being decided. If you look at international investment arbitration, there could be interests that are outside the immediate interests of those parties involved, should those be taken into account. That has, again, like I said, that's been discussed in human rights, and I think it would be relevant to discuss that also when it comes to climate change. I heard one commentator say that when it comes to the human rights perspective, that arbitrators need to wake up to the possibilities of other interests, and perhaps parties need to wake up to those possibilities as well in future cases. And I think there's a lot we could discuss here, when it comes to how long one could expand that. No, of course, one should never move outside the boundaries on predictability. So this is a very delicate balance. Arbitrators and parties are always bound by the law. But when you have language like you see here in 26.6, I think there's some interesting development or systematic integration of other areas of international law that could take place here. And my second bullet here on sort of when it comes to the observations in how international investment law will play a role for climate disputes in the future. I do think that in the fossil phase-out cases that are now being filed, or that have been filed and that are now being that are pending and they are sort of in the process of being decided, it will be very interesting to see how tribunals analyze the investors' legitimate expectations of regulatory stability versus the state's right to regulate and other sort of interest in that other side of the scale, in that balancing act. We try to give some interesting examples in the report on different sort of roads that tribunals have chosen there. Where do you draw the line for the right to regulate, and what are the expectations you could put on an investor, for example, when it comes to due diligence. Again, I think that could be an interesting discussion, and it will be very interesting to follow these cases closely as we learn more about them. I will go to my last slide and return to the quote that I picked from another commentator, that arbitrators need to wake up to the possibilities of other interests. And this is to reaffirm, this is one of my favorite quotes from the last year, and this is by John Kerry. You see the quote there. I do think that climate change is a perspective that is not exclusive, for example, for environmental lawyers or international climate law specialists. It is really much, much wider than that. It's a perspective that I hope that you all will bring with you into your practice, and that you will always have that perspective or with you, or those glasses on, as you move into any types of setting, any type of dispute or transaction, or what the case might be, because the law will play an extremely important role going forward as we transition to a low carbon economy. And with this, I think I close and hand back over to Jessica.
Thank you very much, Annette, for sharing the findings of this really important and groundbreaking jurisprudential study on the interaction between the ECT, the Paris Agreement, and international climate change regime, which will no doubt be a helpful resource for both arbitrators, counsel, academics who are facing the really difficult issues of where you have a conflict between environmental law and investment protection in the cases coming forward. And there has been an anticipation that there will be a wave of decarbonization cases, as you mentioned. It certainly raises a lot of interesting questions for discussion. I certainly have a few questions myself. So I'll now kick off the Q&A section of the webinar and invite the panelists to turn on their cameras if they haven't yet, and also invite the audience to please send through any questions that you have through the Q&A function at the bottom of your screen. I'm going to start off with a question to you, Annette, which touches on your second last slide about the interpretation of investment protection standards under 26.6 of the ECT, as well as the individuals who are involved in arbitration, which I think is an absolutely, a very relevant point that's often overlooked. And it's a bit of an academic question, but it has a practical implication, and it's about the fragmentation of international law. And much has been made about the fact that environmental law and investment protection are both branches of public international law that have evolved with very limited interaction really up until now. And it's been said that in fact that they're operating in silos. When considering the role of international climate law in the sphere of investment arbitration, it's been suggested, and as you mentioned in your talk, that systemic integration could be applied by tribunals to strike a balance between investment and non-investment concerns, including, for example, incorporated exterior, which is applicable to the relationship between the parties given the near universal adherence to the Paris Agreement. And so my question is, which tools can tribunals rely on to incorporate environmental considerations when interpreting concepts of investment law? And in your study, have you come across any signs that the individuals that are deciding these cases, the tribunals, are whether they're
Thank you. No, you are right. The fragmentation of international law is an issue. I think our international or entire modern society is very fragmented. To be honest, we appear not to be very capable of thinking of several things at the same time. You know, we focus on one thing at a time, and that can be harmful as we try to develop societies. But I do think that the fact that we are having this conversation now is a very good sign that sort of the growing awareness of the potential detrimental effect of the fragmentation of international law. So that's a good start. We haven't, unfortunately, seen a lot of sort of the growing awareness of the systematic integration in the studies of in the cases we have studied. There are some tribunals that look beyond, and obviously the Vienna Convention is I would say fairly frequently discussed in the cases. So that clearly is a very, very important instrument, and I hope that that can be used even more going forward when it comes to sort of again waking up to the bigger picture and other interests, both from council side and from tribunal side. And language like you see in Article 26.6, what do you mean when you say that you should decide the dispute in accordance with the treaty and applicable rules and principles of international law? To, if I dare say so, to be a bit bold here, perhaps, again, both from council side and from tribunal side. Some tribunals will be very careful they will be very conscious of how issues have been decided by previous tribunals. I would say all tribunals are very much aware and are very clear on that they are independent, in the sense that there is no precedent from previous tribunals, in the sense that they are bound by the previous tribunals and the conclusions they have reached. But there is still a lot of sort of referring back to previous tribunals, both from council and from tribunals. And there is of course value in consistency in the international legal system for everyone involved. So there is value to that. But again, I think perhaps there will be a time when someone takes a bold decision and does something different for the sake of, for example, the principles as contained in the international climate law, and what we know, what science tells us about what that means in practice when it comes, for example, to policy design. So I think there is still a way to go here. But I suppose the best signs of a shift is the fact that we are having conversations like this one here today.
Yes, indeed. I agree entirely. I think, it certainly is interesting to see environmental considerations in the way that it has evolved in the investment jurisprudence. Often, as you say, not necessarily a consideration directly of the international climate change regime, but a natural incorporation of environmental considerations in when you have a dispute in inherently dangerous sectors such as the extractive industry, and having environmental considerations being brought in, not even necessarily by reference to the Vienna Convention, but just as a natural consideration when looking at, for instance, the proportionality of a police powers measure and whether or not, the state's right to regulate is proportional in the context in light of environmental considerations in dangerous polluting industries. So it will be interesting to see as the international climate change regime becomes more directly invoked in investment treaty arbitration, whether and how that will be incorporated by the tribunals, either as fact or through some of these mechanisms which we've seen in the past. Thank you so much, Annette. I'm going to now turn to a question for Ned. It was a question that that came from one of the cases that you discussed on your last slide. Actually, it's about the Klein Earth versus Shell case, and the one that was most recently filed about 2 weeks ago. I think it's quite interesting because after Kleinert's successes in the Netherlands, we now see a case being brought in the United Kingdom under Section 172 of the Companies Act. It's a derivative action which Kleinert has filed as a shareholder of Shell for failure of the board to adequately respond to the ruling in Milieu Defensie and Shell, which, as you explained, was a ruling from the Hague District Court, which ordered Shell to reduce its group-wide carbon emissions by 45% compared with 2019 levels by the end of 2030. Shell is, of course, in the process of appealing the decision and maintains that its climate strategy is consistent with the Paris Agreement. But Kleinert says that its interim targets would, in fact, result in a 4% increase in emissions by 2030. So if successful, this would be the first derivative action of its kind, which could force the board of a private company to align its climate strategy with the goals of the Paris Agreement. And this could be done by way of a mandatory injunction. And it could also declare that Shell's board has acted in breach of its statutory duties. And so I'm really interested to hear what your opinion is on the potential of Section 172 of the Companies Act to enforce the ESG strategy of major emitters established in the UK and the Paris Agreement in particular.
Thank you, Jessica. So Section 172 of the Companies Act is the general duty of a director to promote the success of the company. So it's really the core of a director's duties under English corporate law. And the claim, it's got a really powerful starting point because Shell is in breach of the Dutch ruling. It's a derivative action, which means that the permission of the English court will need to be granted for the claim to progress. So first of all, it will be very interesting to see whether they get that permission. I suppose my concern with it is that if you look at environmental claims and financial services claims, a number of other claims, British courts are pretty conservative. And don't really tend to be claimant friendly. So I do think whilst it's got a really powerful starting point, we'll have to see what judges do with it. I think in reality, the approach of other shareholders will be important, both because in a derivative claim, their views can be taken into account, and just because certainly my experience of judges is that they, a claim like this will have more weight if they can really see institutional investors getting behind it. I reading around the way institutional investors have approached Shell, I'm hopeful that some will. So it's a great claim because it's kind of route one. It's going straight to the core of the director's duties and saying that they're in breach. Well, let's see how it ends up. I mentioned the kind of disclosure claims earlier on in my presentation. I do think that those sort of claims, whether they're under Section 90A of FSMA in relation to listed companies or in misrep, may end up in the end being easier, because in some ways I think British judges don't like to interfere with boards' discretion to manage companies unless they absolutely have to. Whereas I think it's easier to say, well, look, there is a non-disclosure here. That's an easier thing to pin on a company. But let's see what happens.
Yes, I agree with you. The burden to establish standing under Section 172 is notoriously high. So we'll see if the English courts are as activist as their Dutch neighbors. I think sticking to the topic of climate litigation and the Netherlands. I actually have another question for Annette about the role of climate litigation in ISDS, because we have started to see some interaction between the two, and which have now resulted into Energy Charter Treaty arbitrations. And my question is really about how to reconcile the science-driven mitigation outcomes with investment protection under, international investment agreements like the ECT. In light of the connection to the phenomenon of the global rights-based climate litigation to enforce the Paris Agreement, which has relied on the science of successive IPCC reports as evidence of the need for states to ramp up their ambition under the Paris Agreement, and which has in turn resulted in changes changes to energy policy, which in some cases, has been considered drastic and a major change of circumstances for investors operating within the jurisdiction and given rise to claims under international investment agreements. So I'm thinking, of course, of the Urgenda case, where the courts have ordered the government to either set clear provisions for or meet specific reduction targets. And we've seen this in the Netherlands, we've seen this in France with the Notre Ferratus case, and we've also now seen it in the Neubauer Germany case. So my question is, you noted in the study that that decarbonization policies are really just starting to be tested in ISDS. And so my question is, what role do you envisage, really, if any, of these national court judgments to enforce the Paris Agreement in arising in state defenses and potentially even in the tribunal's reasoning based on the trends observed in the climate change study?
Thank you. I think there are many interesting sort of conclusions that can be drawn if you look on the climate change litigation universe and the way it has developed over the past years. I think, for example, one of the very inspiring, I suppose one could call it, conclusions is that this is a global practice of law, so to speak, that these global instruments are trickling down to national courts. So if you look, for example, at the Shell judgment from the Hague District Court last year that Ned mentioned, if you look at sort of the instruments that the court reasons around and applies, it's just really fascinating. It's so you have the European Convention on Human Rights, but you also have the SDGs, and you have sort of this recognition of that it's a general global understanding that we need to address climate change. So I find that very, very interesting. That we don't see that in international investment law, and I don't think maybe it will be difficult to see that in the short term. But I do think that the recognition of the fact that these principles matter on a systematic and global scale could be relevant also in an international investment law context. I also think it's interesting because if you look at sort of how national courts carve out the standards under their domestic law and how that meets the expectation you could have then on the state when it comes to the fact that they have signed, for example, the UNFCCC or the Paris Agreement. You saw that in the Urgenda case, where the Dutch court sort of had reasoning around the standard of the duty of care that is attributable to the Dutch government vis-a-vis citizens under Dutch law. So you look at the duty of care as attributable to the government in that setting. I wonder how far the step is to sort of import that reasoning on what expectations could you have on a state when it comes to the state always acting in the public interest, as, for example, as you carve out the details of the standard of legitimate expectation. So if you can expect the state to always act in the public interest, and could you then be surprised by the fact that they are acting to reduce greenhouse gas emissions within their jurisdictions? For example, if you are the private party in that dispute. And also, I think to the extent that the growing awareness of the meaning of these instruments that are being negotiated, the meaning of the Paris Agreement, what does that entail in practice? Because we learn more and more about the science, we see more and more how the private sector is contributing and adapting to the realities of climate change. So how does that influence, again, when you define the standards of legitimate expectation? What expectation could you have on regulatory stability in a reality like that? Of course, each fact of each case will be decisive, and who said what and when, as in every dispute, I suppose. But I do think that this growing awareness, what these international instruments actually leads to in practice, and the expectations they put on private corporations. And again, the cases that Ned mentioned and that you just discussed in the previous question is a very good illustration of that. I think it will be difficult not to have that, find its way into the legal argumentation and legal arguing also in the investor state cases. I do hope. I look forward to reading those submissions from the council and involved.
Yeah, thank you, Annette. I think that your observation and your question really goes to the heart of the matter, where you have a dramatic change of circumstances and a duty of the state towards, to ensure that it enacts public policy in the interest of its people. And then really just the issue of, okay, so even if you do have a legitimate expectation in that context, where should the liability fall? And I think that that's really an area where some of the environmental reasoning that's making its way into the discussion, even if it doesn't necessarily actually influence liability, it is actually you are actually starting to see it influence, in the discussion of damages and the amount of damages that are actually due, whether, the amount of investor due diligence, whether or not they have actually ensured that the investment, even if it's an ongoing investment that perhaps started before the adherence to the UNFCCC. I mean, it would have to be a really long time ago, or the Paris Agreement, to ensure that at least that, as an ongoing concern, that it had adapted to the growing reality of, the regulatory environment in which it was operating. So that, I think, is going to be an interesting question, and one for future research as to how, if it ultimately not going to a question of liability, how it will ultimately impact damages in this context, which can go a long way to, alleviating the pressure on the state and this so-called question of regulatory chill. So we have one question from the audience, which is to Wolf, and Ned has graciously agreed to step in and answer it. The question is from Mary Sharon O'Bara, and it's about what types of initiatives should we put in place to educate, ourselves as an industry about the use of the different types of alternative dispute resolution to avoid disputes with regard to the energy transition. And Ned, I'll turn this one over to you. Thank you.
Thank you. Really good question. And actually, there was a Chartered Institute of Arbitration arbitrators working group last week, and we were really discussing just this. I'd suggest that in some industries, like Wolf said, ADR is kind of embedded already, and in construction, which is going to be key for energy transition disputes, ADR is well known, and you have dispute escalation, you have dispute boards. In, for example, financial services, certainly my experience is much more likely you just say all disputes go to English court, and there's much less of that. So I think there's some industry-specific education. I do think in international arbitration, in particular, tribunals don't build ADR into processes, certainly in the same way that I see in the English court. And in the English High Court, it's pretty much mandatory to go to mediation before a trial. And I just don't see international arbitration tribunals building in the same processes. And I do think organisations like MCIArb and the ICC and the LCIA could take steps to encourage arbitrators to do that, because I really think it needs to come from arbitrators. I think just looking a bit more widely, part of dealing with climate change issues is having proper access to justice, and the Aarhus Convention is a good example of the importance of that in climate change disputes. And I think that tribunals need to think about that. And for example, does that come into play in security for costs applications made against claimants in energy transition disputes? I think you can think through some practical reasons why tribunals should be guided to bring ADR and allow access to justice. And certainly the MCIArb is thinking about that.
Thank you so much, Ned. That's a really, really good point about some of the lessons that can be learned from our friends in litigation. I think a lot of processes can also start to be brought over. And I think it's interesting that we're really starting to see quite a bit of overlap between arbitration and litigation as, we're looking at these energy transition disputes. So that is all the time that we have today. I would really like to thank everyone. Well, first, I'd like to thank the panelists for their excellent presentations, and I would like to thank everyone for their participation today. For all updates and information on future Chartered Institute of Arbitrators webinars, you can visit the Chartered Institute website and you can follow them on social media. So I'll just thank everyone again for joining and wish all the Moody's the very best luck in the rounds this week. And thank you all for your attention. Goodbye, everyone. Thank you.
Thank you. Goodbye.
Thank you.